Your equipment is on my son's property. You'll want to move it before this becomes a problem for you." She said it the way people say things when they have never been told no, not as a question, not even quite as a threat, but as the kind of statement that expects the world to rearrange itself in response. She was standing at the edge of my gravel drive in a white linen blazer, a phone in one hand and a printed letter in the other, and she had no idea. No idea that the machine she was talking about, an $85,000 AGCO Massey Ferguson RB 416OV round Baler, still running, still warm, was sitting in a field I owned outright, on land that had been in my family for 3 generations, on ground that her son had driven onto without permission and without the first understanding of what he had taken. She had no idea about the deed in my filing cabinet, and she absolutely had no idea what was about to happen when her son turned around and saw me standing there. Drop a comment and tell me where you're from, and if something like this has ever happened to you, I want to hear it. Let me take you back to where this started. Not to that driveway, not to that blazer, but to the land itself, because without the land, none of the rest of it makes any sense. My name is Dale Cutler. I have worked this ground since I was 11 years old, which means I have worked it for going on 34 years, and before me, my father worked it, and before my father, his father, a man named Earl Cutler who came to this part of western Kansas in 1951 with a second-hand tractor, $400, and a surveyed parcel of 280 acres he had earned through crop share labor and a small inheritance from a great-uncle he had never met. Earl was not a sentimental man by the accounts I have heard, but he was a precise one. He filed the deed himself at the Finney County Recorder's Office in the fall of 1951, paid the recording fee in cash, and kept the stamped copy in a fireproof box that now sits on the second shelf of my workshop, behind the spare hydraulic fittings and a coffee can of zinc-plated bolts. I have opened that box perhaps a dozen times in my life. I know exactly what is in it. The land itself is a particular kind of beautiful that does not photograph well. In early June, when the native grass is coming up along the fence lines and the winter wheat in the east field has gone a deep amber and the air smells of turned soil and something faintly sweet I have never been able to name, that is when I understand why Earl stayed. The property runs roughly north to south, bounded on the west by a county road and on the east by a seasonal creek my grandfather called the Draw, though it does not appear on any map by that name. The north 40 acres are dryland wheat. The middle section, about 160 acres, is mixed-use hay ground, brome grass, some native bluestem, a small stand of alfalfa I put in 8 years ago. The southern 40 is pasture, mostly fallow now, where my father used to run a small cow-calf operation before his knees gave out. I took over full operation of the farm in 2009, when my father had his first surgery, and I have run it alongside my other work ever since. My second income has always come from the Kansas Army National Guard. 22 years, staff sergeant, then warrant officer, then chief warrant officer too. I mention this not to impress anyone, but because it is relevant to what happened, and I will come back to it. The hay baler is the most expensive piece of equipment I own. I bought it 4 years ago at a purchase price of $85,000, and I have made every payment on time. It requires a specific tractor with a PTO rating of at least 100 horsepower, a hydraulic connection, and a driver who has read the manual. It weighs roughly 12,000 pounds empty. I say this not for drama, but because it matters when I tell you that a 22-year-old who had never operated farm equipment in his life decided, one Thursday afternoon in late June, to climb onto my tractor, which I had left fueled and staged in the north field for an early start the next morning, connect the baler's PTO shaft, and drive it across the property line into what he apparently believed was his mother's yard. His name was Cody Hargrove. His mother was Patricia Hargrove, and Patricia Hargrove was the president of the Meadow Ridge Residential Community Association, which is what the development on the north side of the county road called its HOA. Meadow Ridge was a planned community of about 140 homes, developed in the mid-2000s on what had been the old Stanton grain operation before the family sold it. The development sat on the north side of the county road. My land sat on the south side. There was no legal connection between the two. No shared boundary, no easement, no covenant that ran across the road, and no instrument of any kind that gave Meadow Ridge Residential Community Association any authority whatsoever over my 280 acres. Patricia Hargrove did not seem to know this, or perhaps she knew it and had decided it did not apply to her. The first letter from the association arrived in my mailbox in April of that year, about 10 weeks before the incident with the Baler. It was printed on Meadow Ridge letterhead, signed by Patricia Hargrove in her capacity as board president, and it informed me that my property was in violation of community aesthetic standards, specifically that the sightline from north-facing homes in the development was being negatively impacted by large agricultural equipment staged near my fence line, and that I was required to relocate said equipment or erect screening of sufficient height within 30 days. There was no citation, no statute number, no recorded covenant, no reference to any legal instrument establishing how Meadow Ridge Residential Community Association had arrived at the conclusion that it had jurisdiction over my private agricultural land. I set the letter on my kitchen table and read it twice. Then I placed it in a manila folder, wrote the date on the tab in black marker, and put the folder in the filing cabinet next to the one that held my deed. I was not angry. I want to be clear about that. What I felt reading that letter was something closer to professional curiosity. The same thing I feel when a piece of equipment behaves in a way that does not match its specifications. Something is wrong with the system. The question is where exactly and what the documentation says. The second letter arrived 3 weeks later. It included a fine of $250 and a reference to the association's enforcement authority under its community covenants and restrictions. It also noted that the association reserved the right to coordinate with county zoning authorities if the matter was not resolved. I added this letter to the folder. That same week, I called a land use attorney in Garden City named Robert Yen, who had represented my father in a boundary dispute in 2003 and whose number I still had in the back of my address book. Robert Yen was a deliberate man who spoke slowly and billed by the hour, which meant that when he said something, it was worth listening to. I described the letters. He was quiet for a moment, then said, "Do you have a copy of the recorded plat for Meadow Ridge?" I did not, but I knew where to get one. He told me to pull the plat, the association's recorded declaration of covenants, conditions, and restrictions, the CC&Rs, and the legal description of my parcel, and to bring them to his office. He said it in the tone of a man who already had a reasonable suspicion about what he was going to find. I drove to the Finney County Clerk's office the following morning. The clerk at the counter, a woman named Doris who had worked there for what appeared to be several decades and who knew the index system the way I know my own fence lines, pulled the recorded plat for Meadow Ridge in about 4 minutes. She also pulled the CC&R declaration, recorded in 2006, and a supplemental easement document from 2008. I paid the copying fee, 14 cents a page, 31 pages, and drove to Robert Yen's office with the papers on the passenger seat. Robert spread them on his conference table and read them the way lawyers read things, slowly and with a focused stillness different from ordinary reading. After about 20 minutes, he looked up and said, "Their CC&Rs bind the lots within the recorded plat. The plat boundary ends at the county road right-of-way. Your parcel is not within that plat. It has never been within that plat." He turned the document around and put his finger on the line where the Meadow Ridge boundary ended. It ended at the road. My land began on the other side. The association's covenants had no more legal authority over my property than they had over the county road itself. I looked at the line for a long moment. Then I looked at Robert. "So they have no jurisdiction," I said. "None recorded," he said. "Not over your parcel." I asked him to put that in a letter. He said he would have it ready by the end of the week. The letter Robert Yen sent to Patricia Hargrove on my behalf was 2 pages, single-spaced, and it cited the recorded plat by instrument number, the legal description of my parcel by book and page, and the limiting language of the CC&R Declaration, which stated in Section 2, Article 1, that the covenants applied to all lots within the recorded plat of Meadow Ridge Residential Community, as filed with the Finney County Register of Deeds. My land was not a lot within that plat. The letter requested that the association cease and desist from issuing citations, fines, or demands to my address, and noted that any further correspondence of that nature would be preserved as evidence of harassment and considered in any subsequent legal action. Patricia Hargrove did not respond to the letter. She did not send a retraction. What she sent 6 days later was a third letter on Meadow Ridge stationery with a gold-embossed logo at the top, informing me that the association had reviewed the matter and maintained its position, and that my failure to comply would result in escalated enforcement measures. I added it to the folder. The folder now had 4 documents in it. I thought about calling Robert again, and then I decided to wait. I had learned over 22 years in the Guard that there is a particular kind of patience that is not passive, that is, in fact, a form of preparation. You do not move before the situation has fully revealed itself. You let the other party extend. You document. You wait. I did not know, when I made that decision, that the situation was about to reveal itself in a way I had not anticipated. It was a Thursday afternoon in late June, dry and hot the way western Kansas gets, the kind of heat that makes the air above the wheat shimmer and turns the gravel road into something that looks liquid from a distance. I had staged my tractor in the north field the night before, connected to the baler, ready for an early start on the first cutting of brome. I had gone into town that morning for parts and a fuel additive I needed. I was gone perhaps 3 hours. When I came back down the county road and turned onto my drive, I saw the gate to the north field standing open. I had left it closed. I always left it closed. I pulled up and got out of my truck, and I stood there in the heat and the dust, looking at the open gate and the empty space where the tractor and baler had been, and I felt something settle in my chest that was not quite anger and not quite alarm, but was in the same general territory as both. I walked the fence line north, following the track marks in the dry grass, the wide-paired impressions of tractor tires, and the narrower marks of the Baler's tongue, and they led me directly to the county road, across it and into the entrance of Meadow Ridge. Down the main boulevard, where the tracks curved left onto a cul-de-sac called Hargrove Court, which was where Patricia Hargrove lived, in a house with a 3-car garage and a lawn that was the color of money. Cody Hargrove was sitting on my tractor in his mother's side yard. The baler was still attached. The PTO was disengaged, but the engine was running. He was 22 years old, wearing a tank top and sunglasses, and he was grinning the way young men grin when they have done something they think is funny. He had his phone out. He was taking a video. He did not hear me walk up behind him over the sound of the engine. I reached up and shut the tractor off. In the sudden silence, he turned around. He was still smiling when he turned. The smile lasted perhaps 2 seconds after he saw me. Then it stopped. I was in my Class A uniform. I had come from a retirement ceremony at the Armory in Garden City that morning, which was why I was wearing it, why the rank insignia and the service ribbons and the unit patch were all visible and correct. I had not planned this. I had not dressed for effect. But I was standing there in full uniform with my name tape above my right breast pocket and my rank on my collar, and Cody Hargrove looked at me the way people look at something they did not account for in their planning. The smile was gone. Completely gone. I did not speak right away. I have learned, or perhaps learned not to do, the deliberate withholding of words in a moment when the other person expects them. Cody sat on the seat of my tractor with his phone still in his hand and his sunglasses pushed up on his forehead, and for a long moment the only sound in that cul-de-sac was the ticking of the engine cooling and the distant hum of a lawn irrigation system somewhere deeper in the neighborhood, the smell of hot diesel and cut grass mixed in the afternoon heat. I let it sit. "Get down," I said finally. Just that. He got down. He stepped off the tractor the way a man steps off something he has abruptly realized does not belong to him, quickly and without his full weight, as though the machine itself might register his presence as a trespass. I walked around the tractor slowly. I checked the PTO shaft, the hitch connection, the net wrap housing on the baler. I needed to know whether anything had been damaged. The PTO shaft was properly seated. The hydraulic couplers were connected and undamaged. The baler appeared intact, though I would not know for certain until I ran it. I came back around to the front and stood between him and the cab. "What is your name?" I said. Not a question, a request for a fact. "Cody," he said. "Cody Hargrove." I asked him how he had gotten the tractor started. The key had been in the ignition, which I acknowledged to myself was an error I would not repeat. And he told me, in a voice that had lost most of its register, that he had seen it from the road the day before and figured it was just sitting there. He said this as though it explained something. I did not respond to the explanation. I asked whether he had operated the baler. He said he had tried to engage the PTO, but it had made a noise he didn't like, so he had disengaged it. I asked whether he had driven the tractor across the county road without a slow-moving vehicle emblem displayed. He looked at the back of the tractor. The SMV emblem was there, mounted correctly. He said he hadn't thought about it. I wrote nothing down in that moment, but I committed the exchange to memory with the same attention I give to a briefing, because I understood already that this conversation was going to become part of a record. It was at that point that I heard the sound of a car door and the click of heels on pavement, and I turned to see Patricia Hargrove walking toward me from the direction of the garage. She was in the white linen blazer. She had a phone in one hand and a printed letter in the other, and she moved with the particular velocity of a person who has decided, before arriving, what the outcome of a conversation is going to be. She stopped at the edge of the gravel apron at the side of the house and looked at me, then at the tractor, then back at me. "Your equipment is on my son's property," she said. "You'll want to move it before this becomes a problem for you." She had not yet registered the uniform. Or perhaps she had registered it and decided it was not relevant to the authority she believed she was exercising. I looked at her for a moment, then I said, "Mrs. Hargrove, this is my tractor. That is my baler. Your son drove them off my property without my permission. I am going to need you to step back while I make a phone call." The phone call was to the Finney County Sheriff's Office. I made it standing next to the tractor, in full view of both of them, and I described the situation to the dispatcher in the same tone I would use to report a mechanical fault, clearly, with specific detail, without embellishment. I gave the address. I gave the make and model of the equipment. I gave Cody Hargrove's name, which I had just been provided voluntarily. I said I would wait. Patricia Hargrove stood on the grass of her side yard while I made the call. She had stopped walking toward me. The letter in her hand had not been raised or presented. She was looking at me with an expression I recognized from a certain kind of officer I had encountered over 22 years, the expression of a person recalibrating, very rapidly, the degree to which the situation was under their control. It was not under her control. It had not been at any point in the preceding 10 weeks, but this was the first moment she appeared to understand that. The deputy who arrived was a man named Garza, a compact and unhurried officer who took statements from all three of us in sequence, beginning with me. I gave him the facts in order. The tractor staged in the north field, the gate found open, the track marks across the road, the equipment found running in this yard. I told him I had not given Cody Hargrove permission to operate or move any of my equipment. I told him the equipment had a purchase value of $85,000 and that I had a loan instrument on file with a farm credit lender that I could produce. Deputy Garza wrote all of this down in a small spiral notebook with a pen he clicked once before writing and once after. He was thorough in the way that county deputies in agricultural communities tend to be thorough, not performatively, but because they understand that equipment theft in a farming county is not a minor matter. Cody Hargrove, when it was his turn, told Deputy Garza that he had not intended to steal the tractor, that he had only moved it to show his mother that the equipment was a nuisance and that he had planned to return it. Deputy Garza wrote this down without visible reaction. Patricia Hargrove said that her son had been acting on her instruction, that the equipment was a violation of community standards, and that she expected the matter to be handled accordingly. Deputy Garza asked her to clarify what authority she was asserting over the property across the county road. She cited the community association. He asked whether she had a recorded instrument establishing that authority. She said the association had sent letters. He wrote that down too. I stood in the heat of that cul-de-sac and watched the arithmetic of the situation do its work. I did not need to argue. I did not need to raise my voice. I needed only to have been the person who had called, who had a name, a loan instrument, a deed, and a deputy writing in a notebook, and she needed only to have been the person who had told her son to move my equipment, because she believed her association's letters gave her the right to do so. Deputy Garza issued Cody Hargrove a citation for unauthorized use of a motor vehicle under Kansas Statute 21-5801, which covers the unauthorized taking or use of a vehicle without the owner's consent. He noted in the report that the matter was being referred to the county attorney's office for review of potential felony theft charges given the value of the equipment. He gave me a copy of the incident report number. He gave Patricia Hargrove a copy of nothing because she was not the victim and she was not the subject of the citation. She was, in the language of the report, a witness who had provided a statement. She was still standing on her lawn when I started the tractor and drove it slowly back out of the cul-de-sac, down the boulevard, through the entrance of Meadow Ridge, across the county road, and back through my gate. I got out and closed the gate behind me. I drove the tractor back to the position I had staged it in the night before, shut the engine off, and sat in the cab for a moment in the sudden quiet, with the smell of diesel and dry grass coming through the window and the late afternoon light falling flat and gold across the brome field. Then I drove to Robert Yenny's office. Robert was still in for the day. His assistant, a woman named Claire, who always seemed to know before Robert did what a case was going to require, showed me in without an appointment. I sat down across from his desk and told him what had happened in the order it had happened. He listened without interrupting. When I finished, he was quiet for a moment, then picked up his pen and said, "Tell me the incident report number." I gave it to him. He wrote it down. "The citation is useful," he said. "The statement she gave the deputy, that her son acted on her instruction, is more useful. That is her, on the record, directing the unauthorized taking of your property as an enforcement action for an association that has no jurisdiction over your land." He set the pen down. "Dale, she just handed us the civil case." I had come to his office thinking about the tractor. I left thinking about something else entirely. Because what Robert had seen, in the space of 5 minutes, was that Patricia Hargrove had not merely sent letters and issued fines. She had directed her son to physically remove my equipment from my property as a coercive act, as an enforcement measure, under the claimed authority of an association whose jurisdiction ended at the county road. She had put that direction on the record in a statement to a law enforcement officer, voluntarily and without apparent awareness of what she was documenting. The letters in my folder had been evidence of overreach. This was evidence of something with a name in civil law, and the name was conversion, the wrongful taking or exercise of control over another person's personal property, and it carried with it the possibility of damages not limited to the value of the equipment. Robert said he would need a few days to review the incident report and draft the civil complaint. He also wanted to revisit the earlier letters in light of this development, because a pattern of conduct, the letters, the fines, the demands, and now the physical act, told a different story than any single incident on its own. He said the phrase pattern of conduct, the way lawyers say phrases that have weight, carefully and without emphasis, letting the words carry themselves. I drove home in the long Kansas evening with the windows down and the smell of the fields coming in off the road. The wheat in the east field had gone the color of old brass in the last light, and the draw was a dark line in the grass to the east, and the farm looked the way it always looked at that hour, patient and permanent and indifferent to the concerns of people who had not earned a stake in it. Earl Cutler had filed that deed at the Finney County Recorder's office in the fall of 1951, and it had sat in that fireproof box through 3 generations of droughts and crop failures and machinery breakdowns, and all the ordinary accumulations of a working life on the land. It had not moved. It had not changed. It had simply waited, the way a deed waits, for the moment when someone needed to know exactly what it said. Patricia Hargrove had been building a case against me for 10 weeks, letter by letter, fine by fine, with the confident momentum of a person who has never been required to show her work. She had sent her son to my field as a closing argument. She did not know that she had handed me the opening brief. The folder in my filing cabinet now held 7 documents. The deed was still in the fireproof box on the second shelf of the workshop, behind the hydraulic fittings and the coffee can of bolts, exactly where Earl had put it. Robert filed the civil complaint on a Tuesday morning, and by Thursday afternoon, Patricia Hargrove had retained an attorney of her own. I learned this not from Robert, who would have called when there was something worth calling about, but from my neighbor to the west, a man named Gerald Pratt, who had farmed the section adjacent to mine for going on 40 years, and who had the particular gift of knowing everything that happened within a 10-mile radius of his property before most people knew it had happened at all. Gerald called me on a Thursday evening while I was in the workshop cleaning the Baler's net wrap rollers. And he said, in the unhurried way he said most things, that Patricia Hargrove had been seen going into the offices of a firm in Garden City called Whitmore and Associates, carrying a banker's box. I thanked him and went back to the rollers. The banker's box was interesting. It suggested she was building something. I had been building something for 10 weeks longer than she had. The civil complaint Robert had filed named Patricia Hargrove and the Meadow Ridge Residential Community Association jointly. It alleged conversion of personal property and sought actual damages of $85,000, the assessed value of the baler, plus consequential damages for the lost hay cutting and any mechanical damage a full inspection might reveal. It also alleged a pattern of harassment through citations and fines issued under a claimed authority the recorded instruments did not support, and it sought declaratory relief, a court order establishing, formally and on the record, that the association had no jurisdiction over my parcel under Kansas law or any recorded covenant. Robert had been deliberate about including both claims. The conversion gave us the damages. The declaratory relief gave us the record, a judgment that would be filed with the county and would follow the association's name in any future title, search, or boundary dispute. The Hargrove attorney, a man named Sutton from the Whitmore office, filed a response 3 weeks later. It was, in Robert's assessment, thin. It disputed the characterization of Cody's actions as conversion, arguing that he had not intended permanent deprivation and had planned to return the equipment. The same argument Cody had made to Deputy Garza, now dressed in legal language. It also argued that the association's letters and fines were protected communications under its governing documents. What it did not do was dispute the jurisdictional question. It produced no recorded instrument establishing the association's authority over my parcel. It simply did not address the question at all, which in civil litigation is not the same as answering it. They have nothing on jurisdiction, Robert told me when we reviewed the response together. If they had something, it would be in here. The absence is the answer. The matter was set for a hearing before a district court judge in Finney County in early October. During discovery, we produced everything: the deed, the plat, the CC and Rs, Robert's cease and desist letter, all 4 of the association's letters, the incident report, the citation, and a mechanical inspection report from an AGCO-certified technician who had examined the baler and found a stress fracture in the net wrap tensioner arm attributed to the abrupt PTO disengagement Cody had described. The repair estimate was $4,260. We added it to the damages figure. The association produced its governing documents, board meeting minutes, and internal communications that included an email from Patricia Hargrove to the full board, sent 2 days before Cody drove my tractor off my property, in which she described her plan to have the equipment relocated as a demonstration of the association's enforcement authority and asked whether any board members had objections. 2 board members had responded with brief, uncomfortable notes suggesting the association should consult its attorney before taking any physical action. Patricia had replied that the matter was under control. None of this had been privileged. All of it was now in our file. Robert read the email chain twice and then set it down on the conference table with the careful precision of a man placing a document he intends to use. "She put it in writing," he said. She told the board what she was going to do, 2 board members told her to stop, and she did it anyway. That is not a rogue act, that is a deliberate decision made under color of her authority as board president. He paused. It also exposes the board to liability, which is why I expect at least 2 of those members to cooperate before we get to the hearing. He was right. 3 weeks before the hearing, 2 board members, a man named Fessler and a woman named Cho, who had each sent the uncomfortable emails, withdrew from the association's legal defense and retained separate counsel. Their attorney sent Robert a letter indicating that his clients did not endorse the actions giving rise to the complaint and would not be presenting a unified defense with the association. The letter was 2 paragraphs. Robert read it and said, "Good." The hearing was held on a Wednesday morning in early October in a courtroom on the 2nd floor of the Finney County Courthouse that smelled of old wood and the particular dry stillness of rooms where consequential things are decided quietly. The judge was a woman named Hartley, who had been on the district bench for 11 years and who ran her courtroom with an economy of motion I found immediately reassuring. She did not perform authority, she simply had it. Robert presented our case in the order the evidence demanded. The deed, the plat, the CC and Rs, the limiting language of Section 2, Article 1. He read the operative clause aloud. All lots within the recorded plat of Meadow Ridge Residential Community as filed with the Finney County Register of Deeds. He set the plat on the projector and put the boundary line on the screen. He put my legal description beside it. The boundary ended at the road. My land began on the other side. He did not editorialize. He did not need to. The documents said what they said. Sutton's argument, when it came, was a careful retreat. He did not press the jurisdictional question. He argued mitigation of damages, that the Baler had not been permanently taken, that Cody had intended to return it, that the repair cost was speculative. Judge Hartley listened without expression. When he finished, she asked him one question: whether the association had any recorded instrument establishing authority over the parcel described in the plaintiff's deed. Sutton said the association's CC and Rs governed community standards. She asked again, more specifically, was the plaintiff's parcel within the recorded plat? There was a pause that lasted perhaps 4 seconds. Sutton said it was not within the plat as recorded, but that the association's intent had been to address a community-wide concern. Judge Hartley wrote something on her notepad and did not ask another question. The ruling came 8 days later in a written order that Robert called me about on a Monday afternoon while I was checking the winter wheat. He read the relevant portions over the phone, and I stood in my field with the October wind coming flat across the stubble and the sky the particular pale blue it gets in Kansas in the fall when the air has gone dry and thin. Judge Hartley found in my favor on all counts. She found that the Meadow Ridge Residential Community Association had no recorded jurisdiction over my parcel and had no legal basis for the citations, fines, or demands it had issued. She found that the actions directed by Patricia Hargrove constituted conversion of personal property under Kansas law. She awarded actual damages of $85,000 plus the $4,260 in documented repair costs plus attorney's fees under the Kansas Declaratory Judgment Statute. She also issued the declaratory order we had requested, establishing on the record that the association had no authority over my parcel to be filed with the Finney County Register of Deeds as a permanent instrument against the association's name. Patricia Hargrove's attorney filed a notice of intent to appeal within the statutory period. The appeal was withdrawn 6 weeks later. Robert suggested, without elaborating, that the email chain had made the appellate calculus uncomfortable. I did not ask for more detail than that. The Meadow Ridge Board held a special meeting in November and voted to remove Patricia Hargrove from the board presidency by a margin of 6-1. The single dissenting vote was, by all accounts, her own. The association also voted to retain outside counsel to review all outstanding enforcement actions and to issue a formal written retraction to every property owner who had received a citation under Patricia's tenure. I did not receive a copy of the retraction because I had never been a member of the association. But Gerald Pratt, who had a friend on the Meadow Ridge Landscaping Committee, told me about it on a cold November morning while we were both checking fence line along our shared boundary. and he said it with the quiet satisfaction of a man who has watched a long-running piece of arithmetic finally resolve itself. Cody Hargrove's case was resolved separately through the county attorney's office. The felony theft charge was reduced to a misdemeanor unauthorized use of a vehicle, to which he pleaded no contest. He was ordered to pay restitution of $4,260 and to perform community service. The restitution check arrived at Robert's office in January. It was a personal check, drawn on Patricia Hargrove's account, not Cody's. I deposited it and did not remark on whose name was on it. In early spring, when the brome in the middle field was just beginning to come up green along the fence lines, and the draw had a thin line of meltwater running through it for the first time in months, I walked the north boundary of the property the way I walk it every year, checking the cedar posts my grandfather had set, looking for wire that had gone slack over the winter, reading the ground the way you read it when you have walked it for 34 years and know what it is supposed to look like. The posts were solid, the wire was tight. The field smelled of wet soil and the faint sweetness I have never been able to name, the one that comes up in early spring when the ground is just beginning to warm. And I have decided over the years that it is simply the smell of the land being itself, not performing anything, not explaining anything, simply present in the way that land is present when it has been earned and kept and documented and defended. The deed was still in the fireproof box on the second shelf of the workshop, behind the hydraulic fittings and the coffee can of zinc-plated bolts. I had not moved it. It had done its work from there, the way a deed does its work, not by being waved or displayed or argued over, but by existing precisely and permanently in the record. That is the thing I have come to understand most clearly from all of this. When an institution with apparent authority makes a claim against you, when it sends letters on official stationery and issues fines and cites community standards, and moves with the momentum of a body that has never been told no, the first question is not whether it seems legitimate. The first question is whether its claim has a legal foundation. And the answer to that question is never in the letter. It is never in the blazer or the gold-embossed logo or the rehearsed certainty of the person delivering the message. The answer is in the record. It is in the plat filed at the county recorder's office, in the legal description on the deed, in the limiting language of the covenant that the person citing it has never actually read. The record does not care about momentum or confidence or the assumption that no one will look closely enough to check. The record simply says what it says, and it says it permanently. And it was saying it long before the first letter arrived in my mailbox, and it will be saying it long after the last one. Earl Cutler filed that deed in the fall of 1951. He paid the recording fee in cash and kept the stamped copy in a fireproof box. He did not know, when he did that, what he was building. But he built it the right way, precisely, on the record, in a form that held. 3 generations later, on a cold spring morning with the brome coming up green and the draw running thin and clear through the east pasture, I walked the fence line he had set and found it exactly where it had always been. If you have a land story or a boundary dispute of your own, leave it in the comments. I read every one of them, and some of them have become the cases I tell here. If you want to be here for the next one, subscribe and you will be.